welcome to European Union Studies Center event. My name is Patricia Nobel. I'm currently Assistant Director of the European Union Studies Center. And I very much wish my director, Professor Aldensteller, could be here, but she can't be here tonight. She sends her regards and warm wishes. So I'll welcome Professor Hodges in her stead. So Professor Hodges came all the way from the University of Oxford, right? Where he's Professor of Justice Systems. He is also honorary professor at China's leading law faculty at the China University of Political Science and Law in Beijing, and guest professor at China's leading international law faculty, Wuhan University. So he's coming around. And he came here tonight to talk to us about some of the differences between the European Union and American class action approaches and their future based on new EU policies, European Union policies. You'll see that both approaches differ significantly, particularly with respect to, I guess, the expert class representation, group cohesion, and options for refusal of class membership or not. But I'll let him speak and explain for himself. Kristen?
Thank you very much. It's a pleasure to be here. Good evening, everyone. I send my warm regards to Professor Aldensteller. She and I met about 20 years ago in London when she was researching the innovation at that stage of medical device regulation in Europe under European directives. And I happened to be one of the few people who had actually understood what was going on, having read the law and worked with it. So we had a number of very interesting conversations. And in fact, she and I were examining a PhD in the Netherlands last year together, because there weren't many other people who knew about medical device regulation. So it was a pleasure to see her again. This is a very large topic that I'm going to talk about this afternoon. And as you see, I've brought an enormous number of overheads, quite deliberately, because there are several topics that all interrelate here. And in order to get an overview of what is really going on, I think you have to look at quite a sequence of different subjects and different silos, because they all coalesce. So although the title talks about class actions, that is to some extent a tag that people will recognise, whereas quite a lot of this is to do with the balance between public and private enforcement. And I think that is the key difference between the US and what the EU is doing. But we also go into areas of aspects of regulation and what controls business behaviour. The basic question is that one realises that when one looks at American class actions, there are two broad objectives. The easy one, if you like, is to deliver compensation to those whose rights have been affected and who have the benefit of liability. The more difficult question is how do you affect the behaviour of the companies who, or anyone else, it could be government, but it is rarely in this country, who are the defendants. And that is usually boiled down to a single word, deterrence. I believe that that word and those concepts are actually wrong. And if you talk in broader terms about looking at what affects behaviour, then you have a completely different outcome, and therefore you end up with a completely different legal system. And I believe that that is what the EU is currently grappling with and close to putting in place. So I'm going to go quite quickly, I shall speak quite quickly, and I'll go quite quickly through these slides. So the two basic questions underlying all this, which I think society or different groups of societies have to answer, is how do you achieve compliance in behaviour? How do you support compliance in behaviour? And how do you deliver redress, which is the word that's been adopted in Europe in place of class actions. We now talk about collective redress rather than a class action. The traditional answers to these two questions are, in relation to behaviour, we talk about regulation and deterrence, Regulation, generally speaking, meaning public enforcement, enforcement by public authorities like regulators or the police or state prosecutors. And redress, meaning essentially tort liability or other private liability law rules. A very interesting article written in the US by Professors Calvin and Rosenfield in 1941 said, actually, we've got a choice here between public law implementation and private law implementation. What are we going to do? Because they may be functionally equivalent, and that's an assumption which one would question, but it was certainly believed at that time. The problem is, they said, the US at that stage doesn't have many public authorities and public regulators. Many, of course, have come into play since then, especially the 70s, 80s, 90s, and so on. And we don't like them anyway. So you talk to virtually any expert in that area who talks about capture of public authorities. And that is held to, in the orthodox thinking, justify a dislike of public enforcement and to support development of private enforcement. There's a very interesting history in the US of development of private enforcement, which goes following on from the choice that Calvin and Rosenfield suggested in 1941, saying, well, actually, private enforcement is okay, and the idea is that a lot of people, virtually everyone in society, could look after problems, identify problems, and enforce them themselves, which means that you don't need to rely on public authorities to do this task. That means you've got more eyes out there looking at and addressing wrongdoing. So you ought to get greater compliance, and you ought to get greater compensation being paid because more people are doing it, and therefore we will put in place various levers and remove various barriers in order to take that, achieve that end. Another very interesting book written much more recently, 2010, by Sean Farhang, it's called The Litigation State, and that goes through a very fascinating history of, say, the 1960s with the enforcement of human rights legislation, which distinctly shows that there was, in fact, a public authority which was in existence to enforce public, or especially minority and coloured rights in this country. And it was underfunded and it didn't do anything. And it was a deliberate political choice that it didn't do anything. So eventually, both sides of Congress had to agree that they had to do something to enforce the law, and therefore they said, well, look, let's use private enforcement, let's encourage it. That coincided, those events of the mid-1960s coincided with a change in the federal rules of civil procedure in what is known as Rule 23, which is the classic class action law, which was amended and liberalised almost by accident. A lot of writing about this story. And there was then an explosion of private liability because you can aggregate a lot of individual cases within one big aggregate case, and theoretically it is more efficient to do that, so you get more enforcement, and therefore you get much higher level of both a deterrent effect and potentially compensation. The trouble is that system can then go wrong. Now, all the various features around it, you would, if you're going to have a system of private enforcement, you would want to encourage people to bring litigation. You would want to have a system within which there is no loser pays costs rule. You'd have a system of having intermediaries who can be encouraged to do that through contingency fees or third-party funding. Because it's behavioural and therefore punitive, you would have punitive damages and so on. So all these structural features are ones that one finds within the US litigation system, and they make complete logical sense to me as being a logical construct of emphasising private enforcement. None of those changes, by and large, were ever made within the European legal systems. So the basic rule is the loser will pay the legal costs. And contingency fees until very recently have not been a feature of the system in most European countries. It's very difficult to generalise within 28 EU countries, let alone the others. But that is the broad proposition, because we have not taken a decision to prioritise private enforcement. And indeed, we've got quite a lot of public regulatory bodies. So you can see that the seeds of a divergence actually going back quite a few decades. And therefore, I've talked about this sort of two-pillar model of a juxtaposition of public and private enforcement. Now, let's just take time out to look down the behavioural track. I've been looking at theories of controlling behaviour. And there are four aspects that I'd like to talk about. One is the idea of deterrence. One is an economic manifestation of deterrence involving rational cost maximisation, which is extremely powerful in this country, going back to Chicago School economics. All economists talk about it. All antitrust authorities around the world adopt this system. The third is something rather different, which is an Australian and British, basically, approach to regulation and how it is implemented. And then the fourth is much more recent, which I'll mention sometime later on, about social psychology, behavioural psychology, cognitive psychology, and that area has been adopted by the economists and is called behavioural economics. But I think it is somewhat limited if you think about it as behavioural economics, because I don't think it is. I think it's psychology. And if one looks at that area, I think all sorts of issues come into play. So the basic proposition on deterrence is that you maximise the likelihood of the imposition of a sanction when you find someone and the quantum of that sanction. And those two axes that are extremely important, and they together act at the same time and magnify the effect, but you need both efforts, both sides. So you need to identify cases where things are going wrong and make sure that you maximise the actual implementation of the sanction, and also if you put a high sanction on people, the theory goes that's more likely to affect future behaviour. However, when one looks at empirical evidence, what one finds is, in fact, the psychologists tell us, it is the perception of the risk of being caught and punished, which is the implementation part, that is really affects future behaviour. So it's not the fact that the law is enforced, it's the perception that the law is enforced, and it doesn't matter whether it's public or private or social or rules. Whereas, in fact, the quantum of the sanction doesn't affect behaviour. So it's safe in extreme cases. If you're going to go through a red traffic light, you will do it more or less whatever the relatively minimal fine, because you think you're not going to get caught unless you know there's a camera there, which exists in the UK quite often. But you know that it's incredibly unlikely that you would actually be executed for going through a red traffic light. If that happened, if there was a death penalty, then that might have an effect. But almost any penalty lesser than that would not stop people going through traffic lights if they thought that they were not going to get caught. Facile example, sort of made up off the top of my head, but it illustrates the point. Now, so therefore, immediately, one starts to worry about the theory of deterrence, to say, have we got this right? Because if you look in a particular box, you get one answer, but if you look in another box, the psychology box, you get a different answer. You've also got to deal within this theory by the fact that quite often, in fact, I said sometimes on here, people obey social norms or rules voluntarily, in which case there is no threat, there is no perceived risk, but people just do it. sociologists might tell us that an awful lot of our lives we just do normal behaviour all the time, and there is no threat of any penalty. We just do things in order to coexist as humans, all because it's in our DNA, as we would now say. So I'm not saying that these are right or wrong. What I'm saying is there is a significant problem with the basic theory of deterrence here, which is extremely wide-rangingly adopted. Now, the economic manifestation of deterrence is taken into, in enormous detail, the premise that markets, where this theory has much greater force, but therefore actors, individual economic actors like companies, base all decisions on maximising their net gain. They are simply rational cost maximisers. Companies are there to make profit, any trader is there to make profit, and every decision is made on the basis of, do I get money out of this or do I lose it? So that's exclusive economic rationality. Now, the economists have modified that to talk about rational rationality. Therefore, if that theory is correct, the state should ensure that likely costs exceed gains from wrongdoing. So, what you would do after the event is make sure that the cost that the wrongdoer has imposed on others is brought back onto the wrongdoer and then internalised within the internal cost equation. That's fine on a macroeconomic basis, but the question is, again, as a matter of behavioural psychology, does it affect the way people make decisions? And the theory also goes on that companies internalise all cost so that rationally you can adjust behaviour in that way to avoid liability costs. But bearing in mind there's a difference between the ex ante aspect of the decision and the ex post, with the money coming home to roost, if it does. And the theory also has to say that companies can control the behaviour of every single one of their employees, at which point you start to worry again as whether that is actually possible. On this theory, it doesn't matter whether your enforcement is public or private, because functionally, in economic terms, fines are the same as damages. So that's why Kelvin and Rosenfeld were saying there is equivalence here between the two. Public or private enforcement is interchangeable in economic effect. And it says people are deferred by the incidence and the severity of penalties. Well, we've already seen that that's questioned. So you can also include punitive sanctions. Now, this general approach has been questioned, saying that we're not all homo economicus that make rational decisions solely on economic grounds all the time. We're homo sapiens, and all sorts of decisions are taken. And one only has to start reading books like Thinking Fast and Slow by Kahneman to realise that the Homo economicus is actually not a rational description of most people. Some decisions, and indeed some company decisions, might be taken on that on that basis, but there are plenty of others that are taken for all sorts of other reasons, including emotion or how you're feeling, social aspects. I won't go into too much detail here, but one can draw some suggestions here by saying that in the USA, private enforcement, therefore, is intended to cover both the enforcement of public norms, in other words, what we in Europe would call regulation, and private law, tort-based rights, and they're functionally interchangeable. Now, in Europe, we don't accept that automatically, and the legal system has not evolved in a way that we have ever had to think about that sort of proposition. But one also worries about the fact that the effect of any financial penalty, whether it's damages or fines, will be diluted in a corporate setting because of the existence of insurance. So they say it's just a cost of business. We get the money from insurance, we just pool it, and we get the higher insurance prices from everyone because we put our costs up. So it doesn't deter any behaviour at all in the extreme case. So you start to worry about this and ask the question, how do damages or even fines actually affect behaviour? Now, at this point, let me leave that question hanging and go on to the third area, which is an area of scholarship developed, in particular, Ian Ayres, Yale, John Braithwaite is at Australian National University, Canberra. This book, 1992, is the most important book in a sequence of things that are going on right up to date. On the theory of what's called responsive regulation. Now, responsive regulation is not a theory, like the theory of deterrence and the theory of economics. Responsive regulation is based on empirical observation of going around and looking at what enforcers and regulators actually do and how they think they are affecting the behaviour of the people they are responsible for. So, for example, people who, Braithwaite in particular and his wife, looked at care homes for the elderly. One of my colleagues in Oxford looked at water pollution inspectors. And there's a whole range of different situations on railways or mines or lots of social situations and economic situations. And they all say the same thing, pretty much, which was encapsulated within this rather broad theory that's become known as responsive regulation. And the basic proposition is that this is based on empirical research, actual what people do, rather than theory. So there must be something in it. If a lot of inspectors or a lot of enforcers believe that that's what they are trying to do. Now, you have to qualify that because, of course, a lot of public officials don't have the resources to prosecute everyone. But what they do is actually go around and talk to people a lot when they can do that. And this is not true of every situation or every industry. But the basic approach is based on a pyramid of increasing sanctions, and it's easiest to show that diagrammatically. Simply, at the top, Braithwaite says that you should have an ultimate sanction. So, in general, that might be the death penalty. Now, in corporate terms, it would be disqualification of directors or removal of a licence to operate, say for a pharmaceutical company or a mining company or whatever. Or disqualification of a director. And therefore, they say that because of the existence of that, but whether it exists or not, most of the discussions take place at the bottom of the pyramid. And say the water pollution inspectors, they would go around and talk to people and say, actually, I think you need a new pump. And because I think that you're leaching too much pollution into the river or the ground. So you need to spend money on a new pump. Or I think you should do this differently. Now, you can ratchet that up and do a prosecution on that basis. But what's really going to make a difference is if they do it themselves and say, actually, we do need a new pump, or we need to do it differently, whatever. And that's a conversation. It's efficient in terms of use of the public inspector's resource, but it also achieves results on quite a wide basis, is what the research tells us. Certainly, there are examples where, if there is an ultimate sanction or a sequence of ultimate sanctions, then in the jargon, the regulators can speak softly but carry a big stick, which they don't use. But the fact that they've got a big stick means that people will listen to them. So they have got the ability to prosecute if they want, and sanctions can be significant. In many situations, the sanctions that are imposed by European courts are very low because it's actually the public stigma that has the effect. Until quite recently, in most situations, we just don't impose very big fines or very big prison sentences or whatever. But the effect of a prosecution is relatively rare and therefore has a greater public stigma. You can see this within the published enforcement policies that have appeared in the past 2 or 3 years by various regulatory agencies in the UK. It's now been renamed as the CMA, but it was the Office of Fair Trading in enforcement policies in 2012, which is a classic Braithwaite pyramid, because they say education, guidance and advice. Self-regulation, it could be internal or it could be arrangements within a code of conduct within a trade association. Established means trade association arrangement or compliance partners. They could have external consultants they're working with, could be law firms, telling them what to do. Dialogue, warning, formal undertakings given to the regulators, penalties, and only at the top do you get criminal or civil formal court action. It's a pyramid because that is the distribution of what happens in practice. So an awful lot happens down here and not very much statistically happens at the top. The Civil Aviation Authority has got another pyramid exactly like that, completely different sector. This is the Competition and Consumer Authority in the UK. I won't go into too much detail here, but the point I want to note now is how you see a curious merging in public and private enforcement going in, if you like, the wrong direction, going in a way we wouldn't have thought about. So in the UK, we've had a great number of bits of legislation and bits of policy that have been developed over the past 15 years called better regulation in order to save public funds for regulators, but also to reduce regulatory burdens on business. Although the formal burdens are there, there is no removal of the requirements, the substantive requirements on business. They've still got to do the right things, and those right things and the rules keep on growing. It's just a question of trying to make sure that they do it more effectively and efficiently. That's the theory. Now, the point I want to look at is this statement, which is now binding on almost all regulators. We've got about at least 75 national enforcement regulatory authorities in the UK. For very different sectors. And they are required under legislation to observe a regulator's code, and that applies a number of requirements, including these penalty principles, which were written by Professor Richard McCrory of the University of London. The first point to make is it doesn't say your function is deterrence as the only line. Deterrence is there, and it's the last one. What it does say is aim to change the behaviour of the offender. That's completely different, new language. Eliminate any financial gain or benefit from the non-compliance. Now, most regulators would have said until recently, that's not my job. I just prosecute or I talk to people about can they abide by the rules. But this says, no, you've got to remove the financial gain. And it's coupled with aim to restore the harm caused. Now, McCrory is actually an environmental expert, so there's a requirement on the regulator to make sure that people clean up, basically, or make good any damage. Or in other circumstances, it would be paying compensation for loss caused. Now, interesting, therefore, you see a public official being required to oversee the delivery of redress as part of his public functions, whereas previously, that would have been just left to private enforcement. So we're going in the reverse direction. This is tied in with a similar expansion in the purposes of criminal sanctions in the UK. And this was really inspired by one of my colleagues at Oxford, Professor of Criminal Law. He does talk in terms of punishment, reduction in crime. Deterrence appears, but actually almost as an afterthought. But it does talking about making reparation by offenders to persons affected by their offences. And that's backed up by the ability for courts to award compensation. So these are criminal courts taking over what would be a private enforcement function, which means that people don't have to sue. You deal with it efficiently in one place. So parallel move there. We've also got specific powers that have been given and are being expanded to, firstly, the Financial Services Agency and now various regulators in electricity, gas and other utility sectors, to say, well, not only are we going to make you or require you, regulator, to make sure that people are paid back, but if it's a lot of people, we're going to give you what is the functional equivalence of a class action. And the Danish consumer enforcer has got something like this as well. In Denmark, the class action law has two parts. The first part says anyone can bring a class action, but it has to be an opt-in action. This may get too technical for some people who haven't got time to go into the details. It must be an opt-in action. No one does it because it's difficult to do. The second part is an opt-out, which affects everyone, which is what the US class action does. But only the national public enforcer is able to use that. The national public enforcer uses that power almost every day, but in 8 years, I don't believe he's actually yet had to go to court with it, because he uses it as a threat and a negotiating power, rather like the top of the pyramid, along with many other powers that he's got, like accepting undertakings or prosecuting people. So he can say to people, okay, we found out that you've done something wrong, we don't like it. There may then be an argument about whether it is actually a breach of the law or not, and that issue could be referred to court. But assuming it is, he's going to say, you're going to stop that. Now, prove to me you're not going to do it again. What changes are you going to make in your behaviour or in your organisation, in your structure, in your day-to-day standard operating procedures? Are you going to fire people? So I don't have to prosecute them, you could fire them, and that's enough, and it's public stigma, etc. Or for banks, they might claw back their bonuses of the past up to 7 years. You do all that, and we will accept that undertaking, so we know you're going to do it. And you're going to pay people back if you've taken money from them. So the whole thing gets dealt with holistically, dealing with the compensation, the redress elements, and the behavioural elements, if you give the regulator enough powers. It also means, as I said, that the Danish guy and these agencies in the UK actually manage to do more cases because they're not having to run off to court all the time. They're difficult negotiations in some circumstances, but they're usually quicker and more effective. And consumers end up benefiting because they do get paid back. So you're seeing regulatory powers that bring about compensation. There are all sorts of ways within which these powers might be expressed, and I won't go into that, but there are some examples here. I spotted earlier on that 2 of these and possibly 3 of these are the same. But these are recent press cuttings within which regulatory action has forced major companies to pay people back almost before they knew, in many cases, that anything had gone wrong. So it happens very, very quickly. Now, in the EU, you have a different balance in every country between public and private enforcement. In Germany, for example, a lot of enforcement is not public, but it is private enforcement of public law. And what I mean by that is, for example, under the unfair competition law, introduced in, I think, 1909, within 2 years, it was very effectively enforced by a trade body that I always get confused, Verbraucherzentrale, I think, that was put in place. And all companies, all major companies support that. And it's self-regulation because they have the ability to take companies to court. So they're acting as official police, if you like, within the self-regulatory structure rather than the public structure. But that is a different situation from what you would find in the UK or Spain or Italy. So a lot of differences. But what you do see is that as part of the creation of the EU, many people, Majoni, for example, years ago, has been talking about the EU as a regulatory state because the EU produces huge amounts of legislation to harmonise, which are in fact regulation of one sort or another, even if it's regulation of litigation. we're beginning to see debates on what about this difference between public and private enforcement? What should we do? Should we try and harmonise the national structures between, say, Germany and the UK or Spain or France or whatever? But what is clear is that the EU model has not developed in the same way as the US, within which, as I said, primarily enforcement is private, even though there's quite a lot of public enforcement by public agencies here. There is a disconnect between public regulation and how business controls its own behaviour. There's a lot of theorising and discussion about public regulation, but it always stops at the company's door and ignores what companies are doing inside. And quite a lot of companies these days have internal systems, they have compliance officers, they have risk officers, and these two different worlds are not integrated, but could be. And the EU is thinking about how you do that and therefore get more effectiveness and save cost as part of better regulation. So we have, I think, in Europe at least a three-pillar model. And the middle bit that I'll talk about could be called ADR. Now, ADR means alternative dispute resolution, and it's quite familiar to most lawyers. It's usually thought of as being arbitration or mediation that is alongside or before private litigation or class action. So you settle a lot of things, and there are various different forms of ADR. However, ADR is also in Europe being separately attached to public regulation. And the most advanced form of that is what we call Ombudsman in the UK. This is data on county court claims in England and Wales, and apart from a blip around about 2005, 6, 7, the numbers have been going down quite significantly. Quite a lot of this is probably to do with withdrawal by the government of legal aid, so public funding. But the numbers are going down. And if you look at small claims, they weren't that big to start off with in England and Wales, of about 55, 60,000. But they've gone down to, say, 30,000 small claims. And that's for the whole country. Now, remember that figure of 30,000. That's really small in the population of over 60 million people. What we have seen is quite a few countries, 18 or so at the moment across the 28 in Europe, have introduced national domestic class actions. Usually because they've had to respond to a specific problem and the courts have needed it. So in Germany, there was a specific case, big case involving investor protection and whether there was a misstatement by Deutsche Telekom in its prospectus. That was settled here on a class action basis. Germany had to put in place a class action to deal with thousands of claims. But it was limited to that. And similarly, you can see on the right-hand side, there are only a couple that are sort of generic horizontal class actions. Most of them, because they've responded to specific things, are about consumers, generally speaking, or some limited area. They're all different. Every single model of the national class actions is different. On the ground, I won't go through all this data, and it's about 2 years old, but broadly speaking, on the ground, in most countries, there have been very few class actions. The two exceptions for somewhat different reasons are Italy, when they can sue about anything, but it doesn't get them anywhere because the courts are clogged and it's going to take you 10 years to get a single case through. So it's not a class action isn't going to make any difference at all to people. And maybe Poland, where the lawyers have been very enthusiastic about this, although the rate of certification or acceptance by the court is not that great. It's certainly no greater than 50-50. But so far, I don't think any cases have come out of the court system. So you start to worry about timing. But in most countries, especially, say, the Nordic countries, no one sues, by and large. Why? Because they've got other pathways. such as specific ADR arrangements or compensation schemes. In England, the number of our version of the class action is called the Group Litigation Order. There was a spike around about 2001. The decade before was relatively low, and we had quite a lot before that were funded by legal aid and cost rules. Quite a lot of these cases are child abuse, unfortunately, which just came to the fore and were investigated by the police, so people then sued on the back of that. Nowadays, compensation arrangements, as I said, might be included within the criminal prosecution anyway, so these are sort of disappearing. But the broad trend is down. There has been debates about whether Europe should introduce a class action for a very long time, and there's been a sequence of political statements by senior members of the European Parliament and European commissioners that are really very strong, saying, and I apologise for this, the US-style class action is not envisaged. The EU legal systems are very different from the US legal system, which is the result of a toxic cocktail, a combination of several elements: punitive damages, contingency fees, opt-out, pre-trial discovery procedures, and they might have added jury trials. This combination of elements, toxic cocktail, should not be introduced in Europe. Different effective safeguards, including Lisa Pay's blah, 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 are built into existing national collective redress schemes in Europe. Now, that's a statement by the European Commission, which is in extremely blunt and unusual terms, basically saying we just do not like that. And we're talking about culture here, basically. Very strong statement. So what has happened is that the European Commission has produced a sort of blueprint that includes quite a lot of safeguards, saying, okay, well, we may have mass litigation, and the judges may need this in some cases, not very many, but it's not going to be the primary method of enforcement. But where they need it, we need to make sure that we've got the same sort of model across all the EU members. But this is the Commission proceeding quite slowly, not by legislation, because they haven't got political agreement for that, but saying this is a sort of blueprint. And it's got a lot of safeguards in there. Difficult to come out with a definitive list because, as I said, the model in every single European country is different. So therefore the mix of safeguards is different. So the harmonisation challenge is absolutely enormous. A lot of the specific safeguards, these are from an article that two of us wrote a couple of years ago. But one very important one is hiding away here, which says prioritisation of other pathways. In other words, it says you can't use private enforcement or a class action if you've got something else. If you've got a regulatory redress power, or if you've got an ADR or ombudsman arrangement, you've got to use that first, so that the court is the last option. The interesting point is that we're worried about abuse and avoiding, it says avoid redress, that's a typo, if ever there was one, Freudian typo, it should be avoiding abuse, leads to safeguards. The trouble is, the more safeguards you put in place, the less you can use the procedure. Because in the US, the class actions have got, we would say, very few safeguards because you want the procedure to be used as a matter of public policy. Whereas if you put a lot of safeguards in place, it's not going to be used. It's going to be slow and expensive because people have got to pay to overcome a lot of hurdles. And they're simply not going to be able to do it in a number of cases. So therefore, you can see there's clear differentiation in the amount of litigation and the number of cases that are going to be going through the courts. Now, that might be worrying if that was the only option, but there are these other options. There are regulatory and there are ADR of various sorts. So, in relation to consumer redress, we've developed some really quite innovative and promising approaches. Consumer ADR has got a specific approach and a specific architecture now that is being developed. Online dispute resolution, ADR, is global and it underpins any purchases by Amazon, Google, eBay, Alibaba, whatever, that they've got an automatic sort of arbitration-based and sometimes slightly different dispute resolution system built in right from the start that has to be there to support confidence in the trading. But Europe is now taking it further to develop consumer ADR. There are a couple of important bits of underlying data here that it's clearly shown that most consumer complaints are about very small amounts of money. And this is data from 2005 in England, recording certain things. You would expect insurance or finance to be slightly larger amounts of money because pensions, etc., and insurance claims are. But the numbers are really quite modest. Most claims are very small. No one in their right mind would sue for this lot individually. So if you're not going to aggregate them in a class action, what are you going to do? This is not very reliable data from the Council of Europe, but it's the best we've got. There's just been an upgrade published. You won't be able to read it, but that's the point. But it shows that the average time, if you're going to go through a litigation case across a large number of countries, is 287 days. Interestingly, Russia and Azerbaijan claim to be the quickest. Shows a bit of reliability. But the European countries are all around here. Germany is very efficient in terms of its civil litigation procedure, but even that has an average or medium of about 200. And that's not very good. If you've got a very small amount of money these days, you're buying something, and you want to get it fixed. You want to get it fixed then and there. If someone is not connecting you on your mobile or something, you want to get it fixed. You don't have to sue about a relatively small amount of money and wait 200 days and have the cost of all that. So how do we do it? Well, I didn't know what consumer ADR was, so various members of my team and I spent 2 years going around 10 countries, interviewing about 100 consumer ADR ombudsman schemes, which are in this book, hence the plug. And what we found was that in some countries, consumer ADR has been there for a very long time. And for example, in Spain, there's a national network of consumer arbitration courts that exist. They're relatively quick. The same in the Nordic countries, which is why no one sues in Sweden, Denmark, Finland. They're usually not accompanied by mediation, so they're not as efficient and quick as they could be. But they also usually are sort of old-fashioned style arbitration involving 3 arbitrators, and immediately that slows things down. The more modern ones, and the mediation has been is beginning to be included in these. The Netherlands have got a very beginning to think about mediation. The more modern approach is an ombudsman approach, and there are quite a lot of these, some in Germany, quite a lot in the UK, some in Ireland, etc. And they are very effective. So the Telecom Ombudsman in the UK, remember, timing. He settled one case last year in 27 minutes from someone ringing him up, because the Telecom Ombudsman knows all the telecom companies, they respect him, his office has some authority, and he says, pull up this customer on screen. They say this, is that right? Now, it's either yes or no, and he can fix it at that stage. In that particular case, the company said, oh, we've got it wrong. Sorry, we'll pay them back. So they credit the customer immediately. It's just very effective. Things can be done online. Now, not every case can be done within 27 minutes. He aims to do settle most cases within 48 hours. And the statistics bear that out. You see ADR at a European level being put in over quite a few years now. I think the earliest I've got is 2002, or actually 2002, into a lot of individual sectoral regulatory bits of legislation. So a lot of these are very big regulatory pieces, and there'll be one line towards the end saying, and by the way, consumer disputes should be settled by ADR. distance marketing of financial services, timeshare properties, e-commerce, postal services, etc., electronic communications, consumer credit, very important, payment services, coach and bus passenger rights, and now mortgages, and we've got another one. So that's been creeping its way in through the European system. Specifically, we had one directive on mediation generally, but we've now got these two, which are very important. This is Directive 2030, creating a pan-European framework for consumer ADR, pulling together all the national systems, whether they're arbitration-based or ombudsman-based, saying we're going to have complete coverage. We think this is a good idea. We're going to have these for every type of sector, for every trader across the whole of Europe. Now, this directive is to be implemented next year, and it's only a first step within setting up a framework, because traders at the moment don't have to belong to this. That may come in 5 years' time. But it's also set down criteria for the ADR bodies, which are similar to what you'd expect from a court. They must be independent, they must be expert, they must apply the law, they must act fairly, transparently, etc. And the architecture within a country might look like this. You've got a number of traders. You might have a number of consumer ADR or ombudsman bodies. Some countries are going to squeeze that down to one, so they're very visible. And then there will be a regulator, in European terms called a competent authority, that regulates the ombudsman. On a cross-border basis, consumer in country A, trader in country B, it bounces off an ODR platform, which is notionally above Brussels, and then the trader can say, this is my consumer dispute resolution body, which doesn't have to be in the same country, and things will get sorted out that way. Now, this is an architecture, as I say, it's got a little implementation to go, but you can see it's quite significant. Now, I talked about 30,000 small claims in the UK. This is data from 2010, and these numbers have already doubled. In fact, more than doubled. The Telecom Ombudsman has gone up from 100,000 inquiries to 200,000 inquiries per year, and from 25,000 real cases to 50,000 real cases he handles. So he's already bigger than small claims for the entire country. The Financial Ombudsman, which has been in existence for quite a while, is enormous, and it currently gets over 2 million inquiries and handles about 500,000 real cases and resolves them. Sometimes by negotiation, sometimes within a pyramid by decisions at the top. So this is a big structure that is replacing the courts and working together with regulators. It's important to see the Ombudsman as part of a regulatory structure as well, because what the Ombudsman can do is give you real-time information about what's going on in the marketplace. They know, whether it's a case or just an inquiry, what the traders are doing. So the Financial Ombudsman knows what the banks are doing. They now publish that information. Banks didn't like it at all when it happened in 2010, but now everyone knows, and the regulator immediately, or in fact beforehand, starts discussions with the banks saying, what are you going to do about this? Going through the circuit that I was talking about earlier, about saying you're going to pay people back so they don't even need to contact the Ombudsman. Prove to me that you're not going to do it again, and undertake that you won't do it again, put things in place. So you expect the countries that have got ombudsman systems to be quite highly regulated and therefore to have a strong control on behaviour. So one's pulling together within this system the original 2 points I started off with about behaviour and compensation within different structures. That's that pillar, consumer and services trading. We're doing the same sort of thing in modernising public sector ombudsmen that have existed for quite a few years, going back in Sweden 200 or so years, for complaints against the state. The UK ombudsman's a bit old-fashioned, but it's going to be modernised. So you then say, OK, what else have we got? What other types of problems have we got? For personal injuries, we're looking quite closely at bringing about no-fault compensation schemes. Most of us lawyers wrote that off as an idea years ago, but when you start looking at them again, saying this might work, things suddenly hit you in the face about saying this could be a very effective system. You get a lot of information, it would help the National Health Service enormously in relation to behavioural issues, but it would also deliver compensation quite quickly, and it would save the 3-4 million, can't remember the actual figure, the huge amount of figure that the NHS pays on legal fees each year, which could be avoided and pushed back into healthcare. So some quite big changes taking place there. And they come back to new ways of new balance between public and private by looking at other things. But I think they're giving us new answers in relation to redress and behavioural issues. Right, I'm sorry that has taken so long. I won't go at this point into the fourth aspect here, which is to say, how do you really affect behaviour? But if you read Kahneman's Thinking Fast and Slow and all the stuff below it, and Professor Tyler's Why People Obey the Law, you come out with a different sequence of answers to the deterrence ones I talked about at the beginning. Because it says people obey rules, social rules or public, if the rule aligns to their internal moral values, if the rule is made legitimately and applied legitimately, which chimes with the point about perception of it being applied and the risk of it being applied, and culture, the behaviour and support of others. We frequently copy what other people do. So therefore, that tells you lessons about how we should design regulatory systems involving reminders and instilling culture. If one looks through all the papers that have been issued by, say, Basel, World Economic Forum, or European Commission of others, about the financial services crash in the past few years, of course, they got a lot of regulatory changes to strengthen the regulatory system on a global basis, but they all end up talking about culture with the banks. Now, the head of supervision at the UK Financial Conduct Agency is an old friend of mine, and I said, "What are you doing these days?" And I'm spending all my time talking to the chief executives of the banks about their internal culture. They can control the internal behaviour. I can't. I can find out through the Ombudsman and through my enforcement department what's going on if they've not got the culture right. But we've got to talk about culture and ethics beneath all this. We've got to get away from the idea of, these are his words, but I would echo them, from a society within which people are looking out for private profit for themselves or personal profit for themselves. And the economy, proving that the economists are actually barking up the wrong tree by saying, if one puts in a culture within which people are going to make the right decisions, then people don't get missold a mortgage that they can't repay, and so on. Now, difficult to do, but I think there are ways within which we can do that. But this sort of regulatory system is quite close to being crystallised, certainly in the UK, and I think it will spread across a number of other European countries. Whether it is possible to do that in other countries, I don't know, but you can see the culture going with the architectures and the techniques that we're playing with. A lot of this comes down to what, in business terms, would be called a quality system, that you just circulate information, and everyone should do that. It's very similar to what airlines do in airline safety. They are brilliant at circulating information because they have a no-blame culture of saying, that wasn't right, we could have done it better, and they say it rather than not say it. So the EU has a distinct approach to behaviour and enforcement and redress, which differs from that of the US, and looks like it's diverging, but although it's quite innovative. There's extensive public regulation, but there is also an ability to bring in self-regulation and internal compliance. There is a theory that regulation and therefore behaviour is achieved through litigation, but that has limited credibility, perhaps no credibility, at least in the EU, And a firmer base for affecting behaviour has been identified as being required in the EU, because if we just keep suing each other, nothing's going to happen. And we're looking at quite innovative means and techniques and structures. That's an awful lot, and thank you for listening.
Thank you for the overview.
A short version. Okay.
I see a lot of questions. Do you want to pick your
Well,
challenges?
whatever. Yes, keep your hands
To
up.
what do you attribute the difference between the US and the EU approaches?
History. Short answer. Quite complex. Actually, I think that quite a lot of difference. Well, I think that quite a lot of why the US developed the way it does is affected by constitutional and almost psychological approaches. In this country, it was originally founded by people who didn't want to be told what to do. So, personal freedom and personal rights, therefore, Puritans or whatever, escaping from religious intolerance in the UK, in the Netherlands, wherever, and not being taxed by foreign governments without representation, and thirdly. So you see that mistrust, as you find within Robert Kagan's wonderful, quite well-known book called Adversarial Legalism, published in 2000. He goes into this in quite a lot of detail. So I can see why the US has evolved the way it has, but we just haven't evolved that way in European cultures. And if you look at most of the European states, even though they've changed, and Germany is actually a relatively recent state in terms of creation from the 1850s or whatever. France, certainly, England are monolithic, and therefore the predominance of public regulation and the king has a long, deep, integral approach, and therefore we'll go out and do it ourselves and we'll stand up for individual freedoms just didn't develop in the same way. Now, I think that's an interesting angle to look at these developments. I couldn't possibly say what effect that is, but I'm sure that's relevant. But actually, it's just all sorts of accidents of history. I mean, the Rule 23, everyone says, was a complete accident in its expansion in 64, 65. We'll go around this way.
First of all, I have to thank you for this absolutely splendid and fascinating talk. I loved every second of it, and I wanted to try to bring an American and a UK example together, because in The Economist in June, there was an article on corruption in corporations. And I think of BP in Louisiana. Louisiana is, in a sense, a corrupt state insofar as the lobbyists for the energy companies have complete, I would say 95% control over what the state does, so that if you're a tiny 2-acre farmer or something like that, you cannot prevent pollution in your little 2 acres, because everything is saturated with chemicals. And when you talk about co-opting people in the sense that they do wish to do the right thing, I hate to say that the BP...
It depends on the external environment as well. Absolutely. Absolutely right. And indeed, I was talking to the head of safety at British Airways about 3 weeks ago, and he said, our biggest problem, because we've got this reporting culture internally, and my biggest nightmare is if a plane crashes in the US or South Africa. It's happened a couple of years ago, and the public authorities go after them, individuals, because they want scalps, whereas the pilots or whatever are trained to be entirely open and honest. And so you've got a clash of cultures at that point, which doesn't help. So we've got an awful lot more thinking to do about internal and external cultures. in order to get it right. And I remember that Economist article.
Why was BP so quickly corrupted by drilling here or outside of?
I don't know enough of that story. I'm keeping away from it at the moment until it's
I would
quietened
love
down.
to integrate that with your theory.
I think it's a very complicated story.
Right.
And I think focusing on BP itself doesn't tell you anything like the complete picture. Because I've spoken to the General Counsel of BP, who I believe is an extremely honest and respectable guy, who says we're trying to do the right thing. Now, there could be an example that you just can't control everyone in a very large organisation. That wouldn't surprise me at all. And you then ask a lot of questions about the local environment, which is what you were talking about. Similarly, I have heard that that a lot of the farmers within the Ken Feinberg scheme put in inflated claims because they didn't keep records. All sorts of factors come into play there. And I've no doubt it's a very complex issue. And Halliburton deserves as much scrutiny and others
Absolutely.
as BP.
Absolutely. Radix malorum est cupiditas. But I would love to put together your theory with things like that, where something big goes wrong.
Yes. Going round, yes.
So I have a lot of questions. So I guess I want to ask you a little bit more about the deterrence and rationale. As you pointed out, a lot of companies have compliance departments these days, right? Isn't that an indication that the deterrence rationale or the economic rationale is actually working, if either through regulation or through the threat of securities litigation? Why would they do that otherwise?
Yes.
Could we just do away with these? Is it all a waste of money if we were able to implement the perfect law-abiding culture in these companies?
Yeah, well, one can't take this to extremes. It is true that all big companies, any company of any size, will have internal systems, and that's what regulatory systems are built on. So that it's not only internal business systems, but it's external regulatory systems. Pharmaceutical regulation, health and safety regulation, they all require compliance. They all require systems. So you've got to have people to do it. So just deterrence has not affected that. It's just regulation and regulatory architecture, I believe. Also, companies have compliance systems right the way across the world, including in countries that don't use deterrence as a theory. So you can't say that that the existence of compliance departments in this country is just an artifact of deterrence itself. Now, what you do find if you talk to the companies here is that, or indeed American multinationals who operate in Europe, who've then got to report back, subject to US authorities. I've spoken to, these are anecdotal issues, so again, rather like the BP example, one shouldn't take them too far. But it's interesting that I've spoken to senior lawyers in some quite big companies, and they say, and these are European lawyers usually, European nationals, they would say, there is no way I want to find any non-compliance, or I want to find the managing director of a subsidiary involved in a cartel. And if we find that, we will throw them out. They do not conform to our company culture and requirements. Sometimes we've got to keep them because we can't throw them out because they're the only people who know the answers. And we're going to be fighting the regulators, the enforcers for years. So we've got to keep them. But actually, we want to throw them out because it's against society rules and internal rules. And we spend all our time preaching about saying do the right thing, and then these people go and mess it up for everyone. So the company then ends up with a big fine which doesn't change anything. Unquote. So there's an awful lot more one's got to think about here, about values and what affects behaviour. We may come back.
You're talking about a business community, and you're in a global competitive economy, and it's about confrontations of cultural values, and people in the internet age can in fact be at the cross-section of two different cultures or five at the same time and still work for the same company. They can come from one, they can have different allegiances and these can shift. And my question is, I've heard recently from someone who was familiar with the U.S. Marines that their three-word strategy is improvise, adapt, and overcome. And isn't it of primary importance before you impose these regulations that you have some sort of dominance globally, economically? Otherwise, you become too rigid and you risk being able to adapt, improvise, and overcome.
Well, that's not necessarily the culture or the goal of
Right, but
commercial
how
companies.
if you are having if you're having an onslaught from India as a culture or China as a culture, and they're eroding away your business practices by buying up properties, for example, within your own geographic territory, and changing the laws, can you impose such regulations?
I'm not saying that this attempt to introduce an ethics-based culture, basically, would work universally. I think it might work within some countries in Europe, because I think we're almost there. But there are plenty of countries within the world where it clearly would not work at the moment. That gives you, as we were saying earlier, a problem of boundaries and collisions between different systems. But it is rather an interesting concept to start playing with. Now, two other points. Regulation in the City of London, since the 18th century at least, and indeed probably going back at least a couple of hundred years before that, was pretty limited. Certainly within the financial world, because it was referred to as being a small club and there weren't many rules. Everyone knew everyone else, you know, Lloyd's Insurance or the various bankers in their coffee shops. Everyone knew everyone else. And you didn't need regulation, you didn't need a law of contract, because it was a handshake and you'd agreed it, and if it was not trustworthy, they would be ostracised. So that was the enforcement. So self-regulation, Big Bang, leading up to that, the Big Bang happened 20, 30 years ago. And at that point you got an awful lot of players with different cultures coming in and global trading, etc. So you need a lot of rules. And I'm certainly clear at this stage that if you compare the financial services regulatory system to various other regulatory systems, like pharmaceuticals, there were gaping holes in the regulatory system for financial services. And those have had to be filled, which is a pity because you end up with an awful lot of rules. That rules stop people thinking, whereas the Marines, as you say, just adapt to situations they find themselves in. And at that point, you also find collisions of different enforcement culture, both internally within compliance systems and externally in relation to different public regulators. So things get much more difficult at this stage. But it's really interesting how many of the senior banking officials and regulators are talking about culture. That they think that's the answer. That it's in all the major documents that have existed in the past few years. So they are putting in place bigger cultures, and they're saying we've got a global system, so we've actually got to create a global banking regulatory control because it's got to be the same everywhere. Now, in fact, the pharmaceutical regulatory agencies have been talking to each other for years. The FDA and the Europeans and the Japanese and the Australians, etc. They've been sharing information and talking to each other with very similar regulatory structures in the countries, without the sort of gaps that appeared, that were allowed to continue in the financial services regulatory regime. So I think we've got to become global in the regulatory structure, and therefore I think you have to ask questions about how do we affect behaviour, what is the enforcement policy going to be, etc. The really difficult question I find is is bribery within various countries. How do they deal with that? Do we just say no? Because the EU and the US have said you can't do that anywhere. That stand seems to me to be, has to be right, but making it happen is really very difficult. And I think it's really interesting what the Chinese leadership have been doing, saying we're going to stamp it out, is basically what they're saying in their culture. Attacking GSK, but attacking people within the system to string up some very high profile targets. So I think that's quite positive. Yes.
Yes. I lived in Italy for 10 years, and I must say that there is no efficient public or private enforcement. And I'm a big fan of ADR, which I thought that's gonna, in a country where you don't have an efficient judicial system, ADR could be a very positive and good solution to the problem, but that didn't happen since 2011. So what do you think is the problem? Is it a legal system, culture, and what could be some possible remedies to it?
Well, Italy itself, firstly, I have to confess that I've deliberately avoided researching too much because it's a mess.
But it's not the only country. I mean, even Spain, it's not the best practice.
No, it's not the best practice. Although the consumer arbitration arrangements in the autonomous regions are quite okay. They're not brilliant, but they're okay. I've always thought that because of both clogs in public and especially private enforcement, ADR is the only place you can go. So it has to work, and the trade unions, for example, have to negotiate with employers because the system's got to work sooner or later. And I know there's a lot of ADR of different sorts, probably confusingly so, which is why I've stayed away from it, in Italy. An interesting comment, which is second-hand, is that someone whose opinion I respect, who's a professor of civil procedure, said actually the Italian civil procedure is very similar in structure to the German system. But the point about the German system is that you've got to have a lot of judges, and that costs the public exchequer quite a lot of money. Because under the German system, the judges do more work than the lawyers. It's more inquisitorial, if you like, and less adversarial. So lawyers really do not very much, and it's certainly, they don't do a huge amount of discovery and not a great deal of advocacy. So the judges do more work. Germany funds a lot of judges. Italy doesn't. So it may simply be a question of money as to why the court system works there. Now, I don't know if that's true or not, but that was opinion from someone I respect. But I think there's also a Southern European culture of people who want to argue, and ADR helps that as well as other situations.
But basically what happened in Italy is that ADR was paradoxically failed by the lawyers.
ADR was certainly, there has been a very unfortunate history of the lawyers trying to capture developments in ADR and mediation, which was outrageous. So therefore, certain types of ADR have not been allowed to develop effectively in Italy as much as they should have been. And the Italian bar played an entirely restrictive role, monopolistic role, which have stopped things, because I think the rule is that you must have a lawyer if you mediate, which most other countries regard as being ridiculous.
Yeah, I'd like to go back to the changing corporate culture for a minute. Isn't there a problem? You have the same problem with politicians. There's a huge difference between what they say and what they do.
Oh, sure. One can go back to statements that really emanated in the US, and I've only started reading into this relatively recently, into the business management literature. And you can find really interesting mission statements that are made by all big US corporations, going back decades. And you think, I don't believe that. It's just too good to be true. But one then reads quite influential books like Collins and Porras called Built to Last, within which they look at what they regard as being, I think it's about 18 really great companies that have lasted a very long time against a sort of case control of 18 other companies that they say are not so good. And one of the findings of that analysis, and this goes back 20 years at least, I think, their book, is that the companies actually do it, basically. Now, the finding of that original book was not tied to ethics, but it was tied to culture. And so therefore, the business scholars were saying that companies that are going to be consistent, that are going to look out for their customers, actually are going to succeed in the long term and stick around. And they will, like the Marines, be innovative, but they will retain their core values and then say, we're going to try an awful lot of things and see what works, and keep going. And there are two other books subsequently, one quite recently by Collins, that have developed the same line and same sort of results. So one shouldn't trust anyone, but if you think that that's too nihilistic, let's try something slightly more positive.
I've been trying to look at the enforcement of securities law for a research project together with some other people.
Good luck.
And yes, one impression that I had for collective mechanisms of collective redress that is sometimes overlooked is one thing you touched upon briefly, is the distinction between the opt-out system in the United States in class actions, and it seems to me that the systems that are being introduced in European countries, many of them seem to be limited to opt-in, which limits the possibility for a law, because most people will not opt in. And I mean, I do get why continental European lawyers have visceral reactions against things like punitive damages and contingency fees and all that. But with the opt-out versus opt-in, I'm not sure I see it.
Well,
What's your sense?
it's very simple. If you want to use private enforcement as and therefore a class mechanism as a mechanism, you'd use opt-out. But if it's not going to be your main line, and you're going to use other means, a regulatory or ombudsman or something else, you don't prioritise that, and you don't want opt-out. Now, the European consensus, very strong statements by the European Parliament and reflected within the European Commission's recommendation, is opt-in. And I think that it's beginning to dawn on the politicians wouldn't be able to articulate this, but certainly the civil servants below that, the officials, would be aware that they don't want a litigation culture. They don't want that to go everywhere. Now, there's another feature to this, which is how do you control companies making misstatements in prospectuses? I don't believe litigation does that at all, or payments of damages. You have got to think about regulatory approaches, which is what the UK, for example, has always used. It has the power to fine companies, but more importantly, it's got the power to sanction individual directors who make fraudulent statements. If you make a misstatement, then that's a different matter that might not be so serious, and you'd think about what the consequences would be. So one of my colleagues in Oxford was specifically commissioned by the Treasury to do a report on that, and he ended up saying, we don't want litigation, thank you very much. And he was a financial guy. He didn't have any sort of axe to grind on any big approach. So really important is about what are you trying to do? You try to affect the behaviour to stop misstatements. But then what's the effect of the misstatement? People buy and sell shares. They go up, they go down. Just because they go down, should you be able to sue, what's that going to solve? And people like Jack Coffey, Columbia, has been saying for years, it's just money shifting between different pockets of investors, and usually the small guys lose out in those circumstances. So all sorts of questions start arising. Final question, please.
Sir, I hope that this isn't too anecdotal, but what about the notion in ethics of risk-taking, setting LIBOR, banks not wanting to claw back on bonuses? Is that too anecdotal to try to link up to your...
People have just been convicted for setting LIBOR in the UK. And there's an awful lot of potential litigation for people who are claiming that they lost money, or companies who claim they lost money. And that's entirely valid. It's going to be a nightmare sorting it out. But the real behavioural issue is that people are going to jail. And I think the UK's got that right.
You think it has?
Yes.
Yes, I couldn't hear what you said. I suppose the ethical thing is, are our regulators identified with the notion of serving the public or with serving the banks whom they regulate?
No.
Which might be the difference between our non-prosecution and your prosecutions.
Well, one of the reasons why there were gaps in the financial services regulatory system in Europe and certainly in the UK, and it wasn't enforced, was a straight political decision that don't annoy the banks. We don't want them to leave London. And I've had senior regulators tell me that went from the Prime Minister, Blair, as it happened at the time. That all changed 2008 onwards. And all the public regulators, food standards, health and safety, blah, 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 they are all there to serve the public. That's the ethos. And in many ways it always has been. It went wrong, got forgotten financial services. And they were quite annoyed, and the Financial Ombudsman was extremely annoyed because he said they're getting away with murder, the banks are getting away with murder. I know that, but we're not being able to go after them. And it's all changed now. So the deal is, if you're going to do something right, if you prove to me that you're going to have an ethical culture and you're going to try and do your best, I will treat you accordingly as a responsible person. If you find something that's gone wrong, you do something about it and you tell me if it's sufficiently serious. You don't hide it. You then put it right. You pay people back, you sort it out. You make sure you don't do it again, and we'll have a conversation about that. But if anyone internally or you as a bank have done lots of things wrong, or I think your culture is not right, I'm going to be very tough with you.
And how can we begin to go back to that here, except for Eric Schneiderman?
I wouldn't begin to comment on the US because I don't know enough about it, but I just know we're different. I'm quite careful actually in going around European countries. Various governments ask me for advice, but I'm not going to tell them what to do. I actually think you've got, if you were thinking about adopting this sort of idealistic approach, it's quite difficult here because so much is entrenched in a different way.
Thank you.
Thank you very much for coming, for presenting. I'm impressed that so many American scholars came as well. That's often we have a lot of Europeans in our audiences, but this is really pleasant that there was this exchange. So thank you, and thanks to the audience as well.
Thank you.